Hello again. Apologies for the late delivery of this lecture. It'll be a brief overview of Chapter 9's discussion of contract law, both traditional and e-contracts. First of all, though, a few words about your exams. First of all, grades are posted. Most of you demonstrated at least a minimal understanding of the topics of the essay questions. Generally, an essay question demands a more than one sentence response. In future exams, I would hope to see responses with more depth from all of you. You might want to review the suggested responses in the feedback section, particularly if you earned 8 or fewer points on a given question. All right, now on to Chapter 9. Now, what elevates a mere agreement between two or more private parties into a legally recognized contract is the willingness of the public, through its courts, to enter the fray and enforce the contract rights and duties. You need to have some exposure to some of the working vocabulary of contract law. As is the case with all specialized forms of endeavor, a contract has a language all its own, and a basic knowledge of some of the key terms used in contracts will be essential. At least two parties are required for all contracts. One of the two parties has to initiate the contract formation process. The person starting the mutual assent process with a promise is the offerer, and the other person is the offeree. Next, it's a promise. Is it a promise for a promise, that is a bilateral agreement, or is it a promise for an act, that is a unilateral contract? Have these promises been expressly made, or can they somehow be implied from the circumstances? Does the form of this agreement, does it require, that is, certain formalities, such as a negotiable instrument, such as a check or a bank draft, or can it be done in any manner chosen by the parties, that is, informally, as long as the elements of the contract are met? And the answers will vary depending on the circumstance, but all of those scenarios are possibilities within contract law. Now, once the parties have formed an agreement, are the performance obligations already fully met? That is, just by making the agreement, has it been executed? Or are there still remaining performance obligations on the part of one or more of the parties? That is, executory. Somebody walks up and offers to cut your grass and then proceeds to cut it. Does that conclude it? No, there's one more act that's required, you paying for the service. So that would be something that would be required after the fact. Now, in addition, issues of enforceability may have to be examined. If all the elements are in place, the agreement is now considered a valid contract. However, if one or more of the essential elements is missing, the agreement is not raised to the status of contract and may be legally void. There are also certain situations where a contract is created but cannot or will not be enforced. If a legal defense is found to be in place, such as a writing requirement, a contract may be an unenforceable contract. Sometimes certain persons are given legally recognized power to avoid a contract after it's been entered into. These contracts are voidable. Examples of this are a situation that can be found in cases involving young people with limited mental capacity. You find the term voidable contract also more frequently being used in contracts between professional sports teams and their hired athletes. Contracts are voluntarily entered into by parties. The terms of the contract become private law between the parties. Although some contracts, such as illegal contracts, are not enforceable, most are legally enforceable. That means if a party fails to perform a contract, the other party may call upon the courts to enforce the contract. Now, say hi to my little kitty here. That's Trixie. Let's move on here. You should read carefully and understand the various sources of contract law. The sections on e-contracts is rather brief, but it's important, and it deals with the fastest growing method of conducting business of all the world's commerce, electronic commerce or e-commerce. All sorts of goods and services are now sold over the internet. Much of the new cyberspace economy is based on electronic contracts, e-contracts, and electronic licenses or e-licenses. software agreements, and the like. Electronic licensing is usually of computer and software information, but e-commerce has created problems for forming e-contracts over the internet as well, enforcing those e-contracts and providing consumer protection. Now, in many situations, traditional contract rules apply to e-contracts. Many states have adopted rules that specifically regulate e-commerce transactions, and the federal government has also enacted several laws that regulate e-contracts. You'll want to familiarize yourself with the Uniform Computer Information Transactions Act, or the UCTIA. All right, there's a lot more to go through, and you certainly will want to read about it. And a reminder about our assignments for this week. Your IRAC writing assignment concerns the issue of equity. The case is Roma Santa versus v. Mitten, and it's found on page 180 of the text. You'll brief the case and respond to the critical legal thinking questions. And I see there's already activity in the forum on this week's forum discussion. That's the case 9.1 of Facebook versus Winklevoss. And as you read through that case, a lot of you may be familiar with some of the facts in this case, because it has been in the news from time to time. It was a pretty big deal when it first came out. Almost landmark in some respects because of the nature of the business being online and that sort of thing. All right, well, that's enough for right now. We will move on, and don't forget those assignments, and thanks for paying attention, and thanks for reading through the chapters with me as we move along through this semester.